All right, we're going to get started here. I want to thank everybody for being here today. And as I said, we're making a record for the people that weren't able to be here today. And this is, I think, probably the first time we've ever done this and conducted a simulated pro standards hearing. So we're doing this for a couple of different reasons. One of them is because with everything that's been going on with COVID-19, we're now in a position where we're kind of stuck needing to conduct hearings this way, which we've never had to do before. So this gives our committee the opportunity to be able to practice that. And it's also a great opportunity for the people that aren't on the committee to find out what a disciplinary hearing is really all about. So let's start with two different kinds of hearings, right? So we can have a disciplinary hearing or we can have an arbitration hearing. So an arbitration hearing would involve like a money award from one party to the other. Disciplinary hearings are violations of the MLS or Code of Ethics. So that's what we're dealing with today. And for the case study that we're using, we went out to the CAR website where they post all the violators, and which is really quite an interesting site to go look through. And I picked a violation that had quite a variety of articles, and I thought it was really interesting. Nothing local to us here. It was actually an LA-based case, and so we're gonna see what that's all about. So for our hearing today, we've got Jeanette is our complainant, the party making the actual complaint. Doug Slavin is the respondent. He's the one who, allegedly messed up. And on our hearing panel, I'm the presiding officer, and Michelle Tao and Lalena Bracke-Issam are standing in as our additional panel members. Now, typically, when we conduct an actual hearing, we would also have an alternate panel member just in case something happened to one of the three that were originally assigned, but we always use an odd number of panel members to do what we need to do. So there's that. And that's the basics of how we get started. So I'm curious, are there any questions that come up around that at all before we actually just dive right into this? Okay, seeing none. Here's the way we start off. We start any hearing by reading the presiding officer's statements for a disciplinary hearing. And so this is my opening statement. Ladies and gentlemen, I now call this disciplinary hearing to order. The Professional Standards Committee is charged with holding appropriate hearings for the Tehachapi Area Association of Realtors in accordance with the procedures set forth in the association's bylaws for matters concerning alleged unethical conduct or other violations of a membership or MLS duty. The hearing panel meeting here today is a panel of Professional Standards Committee members that has been selected to ascertain the truth in this disciplinary hearing and to render a decision on the testimony and evidence presented. It should be reminded that this is a disciplinary hearing, not an arbitration, and this hearing panel cannot award money damages regardless of the outcome of this hearing. At this time, I would like to introduce the members of this hearing panel. My name is Sally Lawrence, and I am the presiding officer. We also have on our panel today Michelle Tao and Lalena Bracke-Issam. Would you two please raise your hands so that everybody can see exactly where you are? Lena. There we go. Okay, good. I had to see where you were as well because my screen keeps moving around. So I now ask that each person introduce yourself who is a participant in today's hearing. So if you would unmute yourself and introduce yourself as the complainant.
Jeanette Power, I'm the complainant.
And Doug Slavin as the respondent.
Very good. And I didn't ask you guys earlier, did either of you bring any witnesses?
I did not.
No, I didn't find it necessary.
Okay, good. Just wanted to check. We are making an official record of this hearing, and now that the introductions have been made, I want to inform each of you that today's hearing is being recorded. Therefore, typically prior to speaking, we would kindly request that each of you identify yourself so that the recording reflects who is speaking, but because we are actually video recording today, that's no longer necessary. Also, it is really important that only one person speak at a time, and I'm going to ask that you remain muted except when it is your turn to speak. The purpose of recording this hearing is to preserve a record of this hearing in case a party wishes to request a review by the association's board of directors. If, after receiving our decision, a party determines it would like to file a review, the party may purchase a copy of the recording upon written request. Please contact the association staff for the form. No other use of the recording is permitted. All persons present are advised that the proceedings, decisions, and recommendations of this hearing panel are considered confidential. All participants in this hearing are advised that failure to keep these proceedings and the resulting decisions confidential is a violation of your agreement to abide by the association's rules and procedures for this hearing. Our decision and recommendation will only be attributed to the parties, the association staff as required to continue processing this matter, and the association's board of directors for final action. The hearing has been convened to consider the complaint of Jeanette Power against Doug Slavin, which alleges a violation of, violation of Articles 1, 2, 9, and 11 of the Code of Ethics. Before we proceed further, this proceeding is not a court of law and is not governed by the technical rules of evidence that may apply in court. The hearing panel shall seek to determine all ascertainable and relevant facts pertaining to the matter under consideration to arrive at pure judgment and decision that is fair to all parties. The hearing panel has discretion to determine its own rules of evidence and its own procedures to be followed to achieve the objectives of equity and due process. The following has been generally accepted and ruled on by this hearing panel as the procedures for this hearing. A, all parties or their representatives to these proceedings will be allowed a full opportunity to be heard on matters relevant to the issues. The hearing panel may rule at any time during this hearing on the relevance of testimony being given or questions being directed to any party or his or her representative or to witnesses providing testimony. All parties and witnesses will be asked to swear or to affirm that the testimony given is the truth to the best of their knowledge. B, a party may be represented by legal counsel. However, no party may refuse to respond directly to requests for information or questions addressed to him or her by the hearing panel members except on grounds of self-incrimination or other grounds which the hearing panel deems appropriate. In this connection, the hearing panel need not accept the statements of counsel as being the statements of his or her client if the hearing panel desires direct testimony. Counsel is present to advise and consult with his or her client and to speak for him or her subject to appropriate rulings or determinations by the hearing panel. This hearing panel will not tolerate any effort by a party or his or her counsel to harass, intimidate, coerce, or confuse the hearing panel members, witnesses, or any party to the proceedings. The hearing panel may rule at any time on the admissibility of evidence. As presiding officer, I will act as keeper of the evidence introduced at this hearing and mark each with an exhibit identification number and date. All exhibits included in the hearing record may be used in part or full by the hearing panel in their deliberations. The hearing panel members are individually authorized to ask questions as they deem pertinent and significant at any time during this hearing. To preserve order, I will rule on questions or testimony by the parties and their representatives or by witnesses in these proceedings. If deemed necessary, I will order a recess to consult with the hearing panel members or with legal counsel advising the association concerning such rulings. At this time, I request that all persons present in the room that expect to testify at this hearing stand and be sworn or to make the appropriate affirmation in lieu of being sworn. So my next question is, does anybody prefer to be affirmed rather than sworn? Doug, Jeanette? Swearing is fine?
Mhm. Yes.
Yes, I have no preference.
Okay.
All the time.
Then if you would please stand.
I'm gonna get my belly.
Yeah, sorry,
I'm
I can't.
standing.
Okay. See, Doug can do it. Raise your right hand, and following the question I will pose, answer in the affirmative if you do so swear. Do you swear that the statements you are about to make at this hearing are the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Yes.
You may sit down. At this time, if we had any witnesses, we would be dismissing them from the hearing room until it's time for them to actually testify. But since we don't have any witnesses this time, we'll just continue on. All parties should have been mailed or provided a copy of the outline of procedure for this hearing. Do any of you have any questions regarding the outline of procedure for this hearing?
No.
Doug, you're a no? Okay. And I have to keep asking because I'm flipping screens back and forth between what I'm reading and being able to look at you guys. So we can begin now with the complainant's opening statement. Each side should make a short opening statement and should not immediately jump to presenting all of their evidence. The complainant now has an opportunity to make an opening statement to state her case if desired.
In essence, my seller was harmed due to the offer not being complete or transparent by not disclosing that it was a contingent on the sale of their current property. And because of it, my client ended up settling for a home or selling his home for a significantly lower price.
Okay. Thank you. The respondent now also has an opportunity to respond in the form of an opening statement if he would like to.
Yes, thank you for the opportunity. I just wanted to state that the agent who submitted the offer has been licensed for 12 years and should have, you know, he knows what is necessary. And I don't know much more details than that. I don't micromanage my agents, and I know it was a competitive offer, and I dispute the claim that there was damages.
Okay, thank you. So at this time, the complainant will now state her case and present any witnesses. You said you didn't have any witnesses, and then cross-examination of the complainant's witnesses, if you had any, by the respondent would be allowed.
Okay. I have a statement that I wrote that I'd like to read, please.
Sure.
Basically, the seller received multiple counter offers on his home within the first few days on the market, which are exhibits 1 through 8 that I have submitted as proof of offers submitted.
Okay.
The seller chose the cleanest and highest offer. Several days had passed, and I reached out to the lender to see how the loan was processing. It was at that time that I discovered that the buyer needed to sell his current home in order to afford the purchase of my client's house. We tried to make it work out. Unfortunately, the buyer's home was in escrow at the time that the offer was made, but 10 days into the offer, the escrow fell out. As a result, the buyer canceled the contract. I reached out to the agent several times in emails and texts and voicemails, and I never received any respondents whatsoever from the buyer's agent to give me any indication as to what was going to happen on his side prior to the cancellation. I then, as soon as the escrow did get canceled, I reached out to every single buyer who put an offer on the home, but unfortunately, 10 days in, all of those buyers were already in contract on other homes. I put the buyer's house back on the market. It sat there for a few more days, a perceived depreciation of value, I suppose. I got it back into escrow, but at a significantly lower price than any of the offers previously submitted. So that's where the damages, I believe, come in at. Had the seller known that the home was contingent on the buyer's home, it would never have been the offer chosen.
Thank you. And now the respondent has the opportunity to present any evidence or further clarify.
Well, I don't have any evidence, but I wanted to clarify that our offer was very competitive. And one other thing is, I wanted to let you know that we attempted to reach out to, or I should say we, my agent states that they attempted to reach out to the listing agent multiple times. It took them several days to get disclosures. They were extremely hard to get in touch with. Emails were not returned, phone calls were not returned. Once they received our offer, it was very difficult to have any further dialogue. As far as the validity of my agent's buyer, the offer was solid, and I really don't have any more details. You know, like I said initially, he's worked long enough, and he really knows what he's doing.
Okay, thank you. So I have a couple of questions, and then I want to see if any of our panelists have any further questions as well. Jeanette, I'd like to start with you, if I may.
Okay.
Can you tell me approximately what the difference in value between the original offer that failed and what you were able to finally close at was?
$20,000.
Okay. And I'm sorry, what was the purchase price of the house?
$685.
Okay, thank you. And Doug, a couple of questions that I have for you as well is you have not presented any evidence to us. Do you have any proof that your agent actually did make these alleged attempts to contact the listing agent, perhaps a communications log or anything like that?
The only proof I have is a text message that he sent me saying that he reached out to them several times.
Okay.
Again, like I said, I don't micromanage my agents. I have 50 of them under me. I do like to golf. I have my own private life. You know, they're all experienced. I let them do what they need to do.
Okay, thank you. Michelle, do you have any questions for either party? You're muted. There we go.
Why wasn't the contingency disclosed in the first place?
Who were you asking?
Doug.
Okay, I thought so. What little do I know is that, again, I was not made aware that there was this situation. I mean, my agent that works for me is extremely experienced. Like I said, he's been working with me at multiple brokerages for at least 12 years. I think what he explained to me at happy hour yesterday when we went over the details, at least briefly, was that the buyer was considering a cash offer, whether to get it financed. You know, there was multiple considerations by the buyer as to how he was going to go about this purchase. So we just wrote up a really competitive offer, and we're hoping that it would work out.
Does he not know the proper disclosures or did he know that he was supposed to disclose that and chose not to?
I would assume based on his experience, he should know.
Okay, thank you.
Lena?
So the offer that was submitted, what kind of pre-qual was included? Was it a cash offer or loan?
Who is the question addressed to?
Either of you. Jeanette.
Okay. In the offer, it had a pre-approval letter from the lender. So it was my understanding that it was not a cash offer. It was conventional 20% down.
Okay. How far into it did you discover that it was actually contingent?
So we went into escrow on Friday. I discovered on the following Tuesday. So
And so like a week or so?
with the weekend, yes.
Okay.
So let's call it 5 days.
And when did you find out, Doug, that it was a contingent offer?
Oh, when I was just advised that I had a, an potential ethics violation, I was not even aware of this situation. I mean, again, my realtor should know better. I mean, he's been with us a long time. I was not aware of it until we got the notice to appear.
Okay. That's all.
Okay. I just want to hit on this this contingent issue again one more time. When and I guess Jeanette, I'm going to direct this to you because I think you've got the clear records on it. When the contingent property failed, how big was the gap between when that happened and when you found out about it?
So I found out on the Tuesday. It would have been the following. It was 10 days into escrow that the contingency offer failed. So it was probably 5 days after I found out it was contingent. And had it been a cash offer, I would have asked for proof of funds.
Right. So I want to ask the question differently because really I'm just curious if you believe you were timely notified that the contingency had failed.
I gave a 2-day notice to perform. And after I discovered that the contingency, that the home that was in escrow failed, I gave a 2-day notice to perform, and they immediately canceled.
Okay, got it. Thank you. So I'm going to ask again if there is any further evidence that either party would like to submit. And for our panel members, do you have any further questions you would like to ask before we move on to closing statements?
No.
Lena, you good? Okay. So at this time, the complainant can now make her closing statement.
Oh, I forgot this part. So essentially, my client had, within the first 3 days of being on the market, 4 really super strong offers, between 20% down. Unfortunately, we didn't get a cash offer. And again, those are in the exhibits 1 through 8 that I submitted to prove that, in fact, we did receive multiple strong offers. We chose Michael's offer specifically because it was the highest price without a contingency. There were other offers that were contingent with fewer inspections, also at above listing price. So we chose it based on all the information before us. So had I known it was contingent, it was obviously not the highest and best offer for my client. My client did lose $20,000 in my opinion, because we ended up getting into escrow and selling it for $20,000 less. So, putting it into market and then closing and taking it off the market or off of pending 15 days later, there's a perception of something being wrong with the home. And unfortunately, perception equals value in this part. So I do believe that my client was damaged by this.
Thank you. Doug, you may now, as the respondent, make your final closing statement.
Okay, 2 points I just wish to focus on is, first point, we submitted a very competitive offer by the fact that it was chosen, and second of all, we attempted to reach out to the listing agent several times. At least that's what I've been told my agent has tried, with no success. So to say we were unresponsive is inaccurate, and actually we attempted to reach out to them several times and were not able to get through.
Very good. Okay, ladies and gentlemen, if there is any additional testimony or evidence that you would like to present, now is the time to do so. Is there anything else from Either of you? No?
Nope.
I do have one more question for you, Jeanette, because it's the same question that I asked Doug. Do you have a comm log that you would want to submit that shows what your communication issues were?
You know what? I did not produce a comm log, and I should have.
Okay, I just thought I'd give you the opportunity to do that. Thank you.
Mhm.
I now ask that each party answer affirmatively to the following question. Do you feel the processing of this matter by the association and today's hearing procedures were fair and afforded you every opportunity to present your case? Doug?
Yes. Yes.
Jeanette?
Yes.
Thank you. Ladies and gentlemen, thank you for your evidence and testimony regarding this matter. We will next go into executive session and deliberate our decision. You'll be notified by the association of our decision. This hearing is officially adjourned and you are excused. Thank you. Okay, so what we would typically do now is when the parties leave the room, and what we'll be doing when we do this for real in a hearing next week is we'll actually be throwing our complainant and respondent and any witnesses back into the waiting room on Zoom so they can't hear or see what we would otherwise be talking about. And then Michelle and Lena and I talk about what it is that we heard and what we think should happen. So we're going to do that now just for a minute to give you an idea of how we would do it. And then I want to open it up and hear what you all have to say about this little situation. So Michelle, what are your thoughts around this?
I think it's an interesting case, and I think that it definitely violates Article number 1. I do think that their offer was misleading by not disclosing the contingency. I would have liked to have asked if the agent has submitted a contingent offer in the past and disclosed it properly, but I didn't think about it till just now.
Yeah,
But,
that would be an interesting point, but I'm not sure. Well, it might make a little difference. I'm not sure it would make much difference. But good thought. Good thought. Lena, what are your initial thoughts?
I think it's pretty clear cut. If it's contingent, you need to disclose it.
The thing that I keep hearing, that I kept hearing from the respondent over and over is, well, my agents are all experienced and, I like to play golf. I don't really need to supervise them.
Yeah, you're supposed to review all your agent's offers.
Yeah.
Mm-hmm.
And this broker essentially said that he didn't even know it was a contingent offer until he was notified of the complaint. So I think that's a big issue that's well worth focusing on.
Mm-hmm. And when Doug was saying he tried to get in contact with the listing agent, was he trying to disclose that it was a contingent offer and he forgot or didn't know?
Oh, that would have been a good question too.
Yeah, again, but you think of it after.
Yeah, and so by the way, folks, this is part of what happens, right? Sometimes we realize after the fact that it's like, oh, well, we didn't exactly get everything. And I just see Terry's question. Is it normal for the agent in question not to attend and just have the broker? In this case, Terry, because the complaint was really focused around how uninvolved the broker was. The complaint was against the broker, not against the agent in this case, which is, kind of unusual. But I thought when I picked this one, I thought, wow, this is really interesting because it says right on the CAR website, no, my agents are all experienced. I don't feel compelled to micromanage or manage at all, basically. So let's open it up. I'd love to hear from you guys what your thoughts are around this. Because typically, as the hearing panel, we would probably deliberate on this for 10, 15 minutes, half an hour, depending on, how difficult it is to figure out, whether or not it really is a violation. And when we're doing it, we're sitting with the code of ethics out with us and referring back to it. Does it count? Yeah, Michelle's got hers out. Mine's up on screen. Does it count? Is it really right? So
Doug Slavin has his hand up.
Doug, go for it.
Okay, what I just wanted to share with everybody, and not as being the respondent, but the little blurb that Jeanette and I were provided, all it really said from the respondents, just so you know the role, what I was given was just that the agent, when the listing agent reached out to the respondent's agent for more information, the calls were not returned. Additionally, the agent failed to return any disclosures, and that the agent or that the broker was not conversant in the hearings. So to me, that really meant there was no evidence, no details, nothing to communicate. So that's why if you said, well, Doug didn't provide much, whereas Jeanette had an 8-point or
8 exhibits.
8 exhibits, it was because that was the personality or the profile that was provided of how the respondent was, almost to the point where it sounded like he was like smug and didn't even care to have a witness, or didn't feel. That's why I said, oh, I don't even think it's necessary to have a witness.
Yeah, and so I will say you actually did. I thought you did a really good job of playing the role that you were assigned, which is like totally not like you at all. So thank you for that.
Right.
Yeah,
Doug and I rehearsed.
Right. We rehearsed.
Doug and I rehearsed so that because we were like, we have no clue how did he get in this kind of trouble? I don't know. Do you think he might have done this? Okay, let's write this down. So that's why I read the script.
Yeah. So, and that's really when I pulled this one off of the CAR website, it really was a case where the agent who had represented the seller was fully prepared, apparently. And when you read what the broker had to say, what the broker's position was, even though the broker was saying that his agent, had made several attempts to communicate, it was not believable.
Yeah.
Mm-hmm.
It really was not.
The happy hour was a nice touch, Doug. That was,
yeah,
that was
I like that.
The practice yesterday. That was a nice touch.
Yeah, for sure, for sure.
Tessa has her hand up.
Tessa?
So just for clarity, this grievance was against the broker for not following up or managing, basically, yeah?
Mm-hmm.
Not the agent.
Right.
And what can you tell us, what are those articles, code of ethic articles that are in violation?
1, 2, 9, and 11, I think. Let me look again.
Yeah,
Yeah,
but I mean, I don't have it in
what
front
are
of me,
they?
so,
Okay, yeah, sorry. So 1 is when representing a buyer, seller, landlord, tenant, or other client as an agent, realtors pledge themselves to protect and promote the interests of their client. This obligation to the client is primary, but it does not relieve realtors of their obligation to treat all parties honestly. When serving a buyer, seller, landlord, tenant, or other party in a non-agency capacity, realtors remain obligated to treat all parties honestly. So the Article 1 is, he wasn't being honest. And Article 2 is realtors shall avoid exaggeration, misrepresentation, or concealment of pertinent facts relating to the property or to the transaction. Realtors shall not, however, be obligated to discover latent defects in the property, to advise on matters outside the scope of their real estate license, or to disclose facts which are confidential under the scope of agency or non-agency relationships as defined by state law. So and I don't care who answers, what's the point? How does Article 2 apply here? Terry, unmute yourself. There we go.
He he didn't give the facts. He didn't do what was important to the whole contract.
Good, good. And the other point to keep in mind, of course, is, he can't blame it on his agent because he's the broker. He's responsible for every transaction that goes on in his office. So that's kind of how that works. So 9, realtors, for the protection of all parties, shall assure whenever possible that all agreements related to real estate transactions, including but not limited to listing and representation agreements, purchase contracts, and leases, are in writing in clear and understandable language expressing the specific terms, conditions, obligations, and commitments of the parties. A copy of each agreement shall be furnished to each party to such agreements upon their signing or initialing. So who wants to tackle the Article 9 violation? What's the violation there?
He didn't put it in writing that it was contingent.
Right.
Mm-hmm.
Yeah, so there's that one. And then 11 is the services which realtors provide to their clients and customers shall conform to the standards of practice
I'll see
and
you later.
competence which are reasonably expected in the specific real estate disciplines in which they engage, specifically residential real estate brokerage, real property management, commercial and industrial real estate brokerage, land brokerage, real estate appraisal, real estate counseling, real estate syndication, real estate auction, and international real estate. Realtors shall not undertake to provide specialized professional services concerning a type of property or service that is outside their field of competence unless they engage the assistance of one who is competent on such types of property or service, or unless the facts are fully disclosed to the client. Any persons engaged in providing such assistance shall be so identified to the client, and their contribution to the assignment shall be set forth. So, where is the violation in Article 11?
He failed to get the service of a 12-year agent, and the broker failed to supervise the way he would be expected to.
Yeah, so he wasn't meeting the standard of competence that would be reasonably expected, right?
Yeah.
Cool. So once we finish deliberations, then the next thing that happens is we have to fill out a document that's called findings of fact. And basically that gives us the opportunity to write out what we thought the outcome of the situation was, so that when it goes to the board of directors, they'll have enough to work with to be able to ratify our recommendation, because the pro standards panel does not determine the outcome or the punishment. We only make the recommendation, and then the board of directors actually ratifies that recommendation. So we do the findings of fact, and then we also have to do another document, which I can't remember what the name of it is offhand, but that's the determination of discipline, basically. So that would include whether or not we're assigning a fine, if we're assigning training, or what else we might be assigning as a recommended disciplinary action in these kinds of cases. So that's how the basic process works. And now I'd really just like to open it up to you guys and answer questions. Hear what you thought about watching it from this perspective. You know, was this useful? Anybody?
And Doug has his hand up.
Doug, go for it.
Yeah, I thought it was useful. Well, just preparing for it, but what it really just reminded me was documentation. I mean, it gets drilled into all of us, and there's probably nothing more important. I mean, and we're all busy, we all fail documenting everything probably as well as we should, but documentation, because how else do you defend? Whether you're right or wrong, you're going to have a defense.
Mm-hmm.
And I think it also falls into the more you're prepared, the less likely you are to have to be a respondent, and the more prepared you would be to be a complainant. If hopefully nobody ever has to be a complainant, but at least you got your ducks in a row.
Good point.
Hey, Sally, we have a question from Lori on the chat. So what amount of fines would be appropriate in this particular case? And did your case study also present what the results were, what the fines were?
Sally, I have in front of me, I mean, I'll share what the ultimate, I mean, unless you want to, what the, if you want to see what the penalties ultimately were.
No, go ahead.
Okay. So my character, if you want to say, was found in violation of the 1, 2, 9, and 11 of Code of Ethics. And as a result of these violations, A letter of warning was placed in his file for 3 years. He was fined $250, and he was required to complete a class on the RPA standard form and a broker supervision class. So they kind of, I mean, the fine seems fairly low considering the region in which it was, the violation occurred, but it covered both a fine, a warning, and classes. So they kind of covered all bases on that.
Mm-hmm. And one second, Jeanette. Interestingly, when I was looking at the CAR website,
Right.
Most of the fines that I was seeing down in LA were like $2,500 for much less egregious things.
Right.
In addition to educational requirements and stuff like that. So the rest of the answer to your question, Lori, really is, it depends. And it depends on a number of different factors. One of them is this a first offense? Because a first offense is going to be, you know, if we're going to assign a fine, it's going to be a lower fine in general. And we do have guidelines around, you know, suggested fines under certain circumstances. But especially in our association, I think we all kind of agree that the goal here is not to be punitive. It's more to be educational. And so, you know, like the last case we heard, and in fact, Michelle and Lena and Jeanette sat on that one with me, and we hit up, we actually had both a broker and an agent that were in the complaint, and we hit them up pretty hard on education and not as hard on fines as perhaps we could have, but you know, we took everything into consideration at that time as we're doing it. So, and the truth is, we don't get a lot of cases, thank God.
Yeah, that's good.
Yeah, that's actually a pretty good thing. So, and this is another reason, yet another reason to have this kind of practice. Jeanette?
Just for clarity, we made those numbers up. We actually don't know what the house sold for or the discrepancy between the two. So because a $20,000, you know, price reduction is not necessarily reflective in the $250 fine. So those were numbers that Doug and I just made up for examples.
Yeah.
Tessa has her hand up.
Tessa, go ahead.
Yeah, so this was just for the broker, right? I mean, they held the broker completely responsible. There was no action on the agent?
There was action on the agent, but it was actually lesser because the egregious part was really the failure of the broker to supervise it all.
Sure.
And I didn't want to make our mock too complicated by trying to bring in both of them.
Gotcha.
Yeah.
Yeah, and I would say that in my last 3 years now going to CAR meetings and sitting in on a handful of professional standards committee meetings with the recent bloom of the super brokerage in the last 3 to 5 years, there is a lot more focus on CAR and their legal team on cracking down on these brokers who, in some cases, you know, I've met some people that have 5 offices and 5 different associations, and we're in the Bay Area where everything comes together, and they have 8,000 agents working for them, you know. So there's a responsibility on that broker to make sure that there's a hierarchy of supervision throughout his organization. And there's, you know, a lot of times where this kind of stuff is happening, where agents are out there not necessarily going rogue, but they're going out there unsupervised and they're making mistakes, and CAR is ultimately putting, you know, the buck stops with the broker, so the brokers are getting pulled in on some of these things.
Right. Nobody's checking paperwork or anything like that.
Right. Terry, what are your thoughts as an office manager?
As far as overseeing or lack of overseeing the documents. Well, to me, this was, I mean, I thought it almost seemed made up to me.
That's what I thought when I saw it.
And Doug's, excuse me, and Doug's response, you know, it was just like, oh my gosh, I can't believe it. I can't believe it. So I was happy to hear that that's the way it was supposed to be played out.
Yes, exactly.
So thank you for clarifying that.
Yeah.
Yeah, I think that you know, there are a lot of brokers and out of area, like Josh said, that are overseeing so many agents, and they're not focused on the agents at hand. And we're lucky that we're not seeing it as much here as you do in other areas. So
For sure. Did you find this useful, Terry?
I did, because I didn't know how the process even worked. So that's why I was excited to sit in on it.
Cool.
So yeah.
And I would say, you know, I'd like it if we all encourage everybody in our offices to watch the replay and maybe post on Facebook, you know, like where I put the link up originally, post on Facebook that, you know, might have been nice to be here. Thank you,
Yeah.
Jeanette. Appreciate it. And Randy says, do you think the complainant would have filed a complaint if the second offer accepted had been at a price as high as the original offer, or is that not even relevant? That's an interesting question, Randy. And I don't know. What do you guys think?
Okay, well, Jeanette and I talked about that because the information we were provided, Jeanette's first question was, did the deal close? You know, we didn't know the ultimate outcome of the transaction, or of the, if you want to call it just one transaction. I think pragmatically, you know what, if somebody sells their house and they get what they want, you know, and chances are they probably just move on. I mean, unless it's, you know, an extremely egregious, if you want to say, offense. I mean, because when it comes down to it, it's a dollars and cents matter. And if they sold the house for, we agreed that if they did ultimately sell the house without the big loss was the motivation for the ethics violation, because that was the damage. That's kind of what we thought.
Okay.
And I also, if I can speak real quick,
Right.
wonder why the lower price, and how long was it in escrow before it closed? Was that the reason? That was the market in an up or a down market?
Right.
It was a 2-month escrow. You know, sometimes, you know, did the appraisal come in too low? Stuff like that. But
in the complaint, Randy, Jeanette had said that based on the market conditions at the time, being off market pending for 15 days and then going back on made the house be stale, and stale equals value.
okay, it does. That's true.
Josh?
Yeah, I would just, to that point, I think it's really dependent upon how each individual realtor looks at their career and upholds their own ethics, whether or not they would have made this complaint if the house had sold for the same price or not. And I think that's one of the messages that we've been trying to send to our association over the last few years, not to be ticky-tacky or running around looking for people to get in trouble, but when you see things that are being done out there that reflect poorly upon all of us, that we need to step up and go through this process, because that's where the learning takes place. And that's where, as a self-regulated group, that's where we educate each other. So I think it really just depends on that, you know, in this case, that individual realtors wanting to uphold their contemporaries to that same high standard that they're holding themselves up to.
And I think, you know, I think also in this case, there are a couple of differences that we don't know about. But for example, if I were the agent involved with the seller and I was having this difficulty with the accused broker's agent being able to actually communicate effectively at the beginning, which is, you know, was part of the problem. After I had made some efforts to do that, I would have gone past the agent to the broker. I'd called the broker and said, look, I've been trying to get a hold of your agent for 4 days now, and I can't get a response, and we've got this problem with the contingent offer.
Yeah, you can't just sit around and wait.
Right. But based on what we did have to work with, I would have expected the broker at that point to say, well, deal with it yourself.
Probably.
And
He
if
was
that,
having happy hour.
yeah, or playing golf, you know, and if that were the case, then for me personally, for my personal ethics, I would have pursued this, even if the second offer was as good as the first one, because he's got a duty. I mean, I'm a broker. I have a duty. He has a duty to supervise my agents. You know, that's the duty. We're responsible for that, and to just abdicate that, to me, is completely and totally wrong. But you know,
Well, one thing is, it is stressful to go through this process, and sometimes here up in Tehachapi, we, being a small community, I think we try to talk to each other a lot more than maybe in a large city. You know, I know that I make lots of phone calls and say, hey, you know, I heard this or you did this. I recently had an agent actually reach out to one of my builders and just said that they had heard that they weren't happy and that they thought they could represent better, which is clearly a violation. But, you know, I reached out and had a conversation. It was a newer agent. And I mean, it's a stressful process. And sometimes up here in our community where we work with each other over and over, it's sometimes nicer maybe just to have a conversation and then see if that person learns something that way. But there is a time and place for grievance, that's for sure.
Yeah, absolutely. Well said. I just want to check in with a couple other people that we haven't heard from yet. Adriana, got any comments?
No, thank you.
Did you find this useful?
Absolutely.
Okay, cool. Well, that's a good comment. Thank you. How about you, Wendy? I'm glad to see you here.
Thanks. It's good to see this mock hearing. I thought it was really good. I've been on the grievance committee in the past, and you only get just a certain amount of information with that training. So to see this process was really helpful, I thought.
Cool. Well, thank you for being here. I appreciate it. How about you, Mark? You have to unmute yourself.
Ta-da.
Ta-da.
Okay. Yeah, I know, just to underscore what Josh was saying, that, you know, bad actors reflect on all of us, and most of us are not litigious and we let things slide, but, you know, it's incumbent on us for our profession to demand adherence to the code of ethics. And when we get egregious violations, you know, rather than let them slide, because if they happen once, it's probably going to happen again, and it reflects badly on all of us. And have true, you know, grievance hearing. It's not that pleasant, but really it's just a few hours of time. And if we're licensed professionals, I mean, we take an oath to uphold the code of ethics, and, you know, oaths mean something. And as far as punitive damages, I believe $15,000 is the maximum punitive damage. And when you see like this test case here for $250 violation and supposedly a $20,000 loss in selling price, you know, I know that was made up to $20,000, but in such a case though, I mean, I'd go for the $15,000. So anyway, that's my thoughts.
Cool, thank you. The other thing I want to make clear is, because Doug mentioned that one of the actions was a letter of warning. So there's two different letters that can go in your file. One is a letter of reprimand, which is less serious, and the other is a letter of warning. And then in conjunction with this, the other thing that happens is if the respondent, sorry, yeah, if the respondent is found in violation, then they also go on the CAR website with their picture. So that doesn't particularly look good to the public or your fellow realtors. So there's that little bit of embarrassment as well to have to deal with all of this. So cool. Anybody have any final thoughts they want to share? We're right up at the top of the hour, and I want to be respectful of everybody's time. Lori, you got anything to add, or?
Let's do it again. I thought
Okay.
it was really interesting. You know, I would hope that that the complainant would have made that, you know, regardless of how the outcome, what, you know, if they had lost money or not, just because I thought it was pretty egregious. I mean, you have to do the contingency.
Yeah.
So, but like Tessa was saying, it takes time, and most of us would just move on.
Yeah, and that's part of the reason I kind of wanted to do this, to let you see that it can be relatively quick. I mean, yes, there is some time in prepping to prepare your case and so forth if you really want it to be effective. Oh, thank you, Carmen. Carmen says that the violator section on the website is currently not public facing, so only realtors get to see it. Maybe we should make it public facing. Huh. Maybe we can get Josh to work on that at CAR. Yes, there is some time involved in it, but I really think that it is well worth the effort to raise the standards of the profession for everybody. Those are just, you know, that's just the way I feel about it. And I think being able to do this periodically is probably a really good idea to keep it top of mind for everybody. And I'm also going to make the invitation to anybody that was here live or is watching the replay. If you think that this might be something that you want to participate in, let me know if you're interested in joining the Pro Standards Committee, because we are always looking to expand the number of our members of the committee. Because one of the things that happens in this process is, let's say, for example, that Terry Gardner's a committee member, and one of the parties involved in the issue is a Miramar agent. Well, Terry's not eligible to sit on that panel. So we would have to be able to pull from someplace else to not do that.
Is our board of directors allowed to be on the panel?
We have used board of directors members as a last resort. So the answer to that is, and I'm going to see if Carmen's going to contradict me here, but the answer has always been, yes, we can accept board of directors members as panel members, but we only use them on a panel if we can't get somebody else to fill the panel.
Because they have to vote on the outcome?
Mm-hmm.
Okay.
Yeah. But there have been times, I mean, I was on the Pro Standards Committee when I was on the board of directors, because we had so few people available at that point. And I think I did wind up sitting on one or two. Okay. I think I sat on one as an alternate and one as a regular panel member. Can't remember for sure. It's been a while back. And Stacy was here, but she's left. Stacy has also asked me to continue on as the Pro Standards Chair during her tenure as well. Yeah, and then the other thing that happens is if the respondent asks for a review of the determination, then that review is done by a board member. Okay. So, cool. Anything else? Y'all good? Again, I want to thank everybody for being here. I really appreciate it. I thought this was fun. I hope you guys had some fun. I thought Doug was awesome. Thank you, Josh, for your help. And he's on a phone call, I see. So, yeah. So thank you to everybody. And yeah, we'll see when we're going to do the next one. And thank you to Lena and Michelle for being our panel members. I thought they did a great job as well. Super appreciate it. All right. Thank you very much.
Thanks.
Okay, bye-bye.
Bye-bye.